Hello, I'm an AV rated attorney, and today, rather than pondering my orb, I was sent a video about Reckless Ben and asked to react to it, so here it goes.
I'm about to go to court, and I don't even know what I did wrong. Yeah, Bricks and Minifigs is making up tons of lies about me to the police to try to get me thrown in jail so I can't release my documentary about them. But the crazy part is...
Weird thing he says really quickly, I haven't gotten much into the video yet, but he talks about the police lying. And a weird thing that you may or may not know is when police are conducting an investigation, they are allowed to lie. A lot of people don't realize that there are no consequences for a police officer lying as long as those lies are made in connection with an investigation.
Right now, I kind of don't even know what I'm being charged for because all of the body cam footage has been redacted, and they say it's to protect the victims. However, I think there are some redactions that maybe don't make sense.
He mentions redactions. What redactions are, you've probably seen them before in documents and things like that. When there are sensitive matters in a document, sometimes you will see the document blacked out in that area. You might be seeing text throughout the entire document, and then in an area where it just looks like it's been completely blacked out so you can't see what was written. And similarly, you might see a lot of different kinds of redactions on video. Sometimes things are just blurred out so that the identity is gone. And sometimes video is just simply blacked out in that area or something else used to mask. What he's saying, they're saying, is that police have redacted their body cam footage to protect people that were in the body cam footage, to protect their identities because they might be witnesses, might not be witnesses, but for some reason to protect their privacy.
I do have some concern in this case with the defendant representing himself. The allegations here relate to the fact that the defendant, he's a person he's a YouTuber, who creates videos, publishes them online, and has been, if this defendant were to represent himself and we were to provide body cams and discovery, we would be now providing additional information and fodder for this defendant to create videos from which he could profit by placing them on YouTube at the expense of our victim. I have serious concerns for that.
Someone, I presume it's the prosecution, is expressing concerns about Reckless Ben representing himself. And what the theory is that if he's representing himself and we show him, because we have to show him the unredacted versions of the video, if we show those to him, he might then use those videos on his YouTube channel to promote something, make some money off of it, to get some clicks or whatever the case may be, which seems like a pretty odd excuse to me. But let me break this down a little bit. There are concerns about a defendant representing themselves. In fact, there's an old adage, I don't know who the quote is attributable to, but almost all lawyers know this quote. And it goes like this. An attorney who represents himself has a fool for a client. Most attorneys, even if they were the best in a certain area, even if an attorney considers himself the best criminal defense attorney in the world, he would not represent himself in all likelihood. Are there exceptions to every rule? Of course. But the reason why you wouldn't represent yourself is because a representative, an attorney, is an advocate. And as an advocate, sometimes you have to be an a-hole sometimes. No, that didn't happen. This didn't happen. You have to be on point, and you have to be often very aggressive in order to prove a point. But if you're being aggressive and you're being kind of a jerk, it's kind of hard to be seen as a victim. If you're saying that you didn't commit a crime, then you've been victimized if that's true. You're someone that's been accused of something you did not do. You're going to have a better chance in that case if the judge and jury perceive you as being a victim. But there's this psychological thing going on in our brains where if someone's advocating, it's hard to see them as a victim. If someone's strong, aggressive, powerful, and a jerk, it's hard for them to wear the victim hat. It is smart to not represent yourself if you've been charged with a crime or even in a civil case. Again, the adage is even an attorney who represents himself has a fool for a client.
They're arguing to the judge that the best thing to do is to not let me know what's being said about me, which is very strange, but That's their argument. And just in case you haven't been following along with this whole Lego story, this is all happening because I stepped in to help a family who got their Lego collection stolen from a company called Bricks and Minifigs.
I'll comment more about this later, but I am intrigued already about this concept of him not understanding the charges that are being waged against him. The reason that he's stating that he can't understand the charges is because they won't let him see all the evidence. That's concerning, but let's comment more on it later as it develops.
And for the last couple months, this company's been doing whatever they can to get me arrested so they can keep all the Legos for themselves. And this isn't even just me speculating. One of their own employees literally told us what their plan was.
I got a call from my boss, and it was like, how do we get them arrested? How do we get them arrested?
There's been a bunch of this in the media and other areas lately, but we've all probably heard the term right now, lawfare. Using law as a weapon to harm somebody. You see it a lot actually in business litigation. There's a huge giant of a business, and then the little guy. The huge giant of a business can employ much more resources than the little guy. The huge giant of a business can pay hundreds and hundreds of thousands for teams of attorneys, whereas the little guy might not be able to afford an attorney, and if so, has to get an attorney that's got pretty discounted rate.
Better call Saul.
And so you can see that an entire army against a single attorney without much resources, without many paralegals and this or that and the other, can make a very unfair balance. And so what it seems to be that he's saying right here is that this big corp is coming after little old me, and they're using lawfare to do so because they're just trying to look for ways to make me relent because they have more resources than I do. So therefore they should win and I should lose, regardless of what the truth is underlying the case.
I'm actually a YouTuber making a documentary on the entire scandal.
So the YouTube guy is named Reckless Ben. I don't want to be on YouTube.
Yeah, this is when things really started getting crazy. Bricks and Minifigs went into ultimate defense mode and was going to do whatever it takes to prevent this documentary from coming out. First, the police got a call saying I had heroin on me.
This officer is going to conduct the search of your person because there are substances in the vehicle.
And obviously, they found nothing. But then they got a call saying that I was the one that stole the Legos. And I got
Reporting a false crime, a crime that didn't happen, trying to get someone arrested based on something blatantly false, is a crime in and of itself.
The judge is looking at signing a protective order to protect Josh and all of his statements about me. If this protective order gets signed, then I'll never be able to find out what he's claiming I did.
I got bad news. I don't think we have any more budget for animation, dude.
Oh, shoot. So how do we animate this next court scene? I guess if we have to not pay the lawyers, then I guess the animation's more important, right?
Yeah, we decided maybe the lawyer.
I touched on this a little earlier. As you can see, they're draining his resources, or at least that's what's being purported by the video, is that his resources are become so thin that it's starting to interrupt the manner in which he produces YouTube videos.
Lawyers are actually more important. So, yeah, we ran out of animation budget. Sorry, guys.
The court's inclined to sign this pretrial protective order unless you have an objection to it, Mr. Schneider, and the objection to such an order.
Yes, I think there's a bunch of misunderstandings in this case. And so this person doesn't want to get exposed, so he's making up a lot of lies about me to order to like get me arrested before he gets exposed. So that's what this whole thing's about.
However, before I was allowed to show any of the overwhelming evidence I have to support my claims, the judge didn't care about the evidence and signed the protective order anyways.
Mr. Schneider, the court's going to...
Unfortunately, when you represent yourself, you might not understand the procedures that the court is looking for. You might not understand what to do in order to make sure that your evidence gets heard. I mean, one example, just an example of what attorneys often do in a courtroom, when it sounds like the judge has already made up his or her mind and doesn't want to hear any of the evidence, an attorney might say, Your Honor, respectfully, I have the right to make a record so that I might be able to appeal this because, as you know, Your Honor, if it's not in the record, I don't have an appealable record. I want to make a record very briefly of the evidence I would intend to show. Even though you might not allow me to present that evidence, I would like to at least make a record of what I intend to show so that I might be able to take this up on a writ, which is like an early appeal before a case is over, or later on take it up on an appeal. And I'm going to tell you that in my experience, most of the time when you respectfully ask to make a record, the judge will allow you to make that record, because the judge not allowing you to make a record at all is grounds for reversal on appeal. And so they will generally do that. And you'd be surprised. As attorneys, we know that when you do that, you often change the judge's mind right there on the bench. They change their mind entirely after you've said, can I make a record? And then you make your record. They go, oh, maybe I do want to hear about this. And maybe I do want to hear about this other thing you have. What evidence do you have on the allegation you said that you would, if you could make a record, you would intend to approve X? Let me see X. What goods do you have on X? Ben didn't know to do something like that. And so judge didn't look at any of it. Not surprising.
But I'm also being charged with another case in Provo, Utah. This is where corporate Bricks and Minifigs is, which is why I'm also being charged here. And this police department has surprisingly actually followed the law when it comes to discovery. This was the state's response.
My name is Nick Mielstein. I'm the prosecutor. Is Benjamin Schneider here?
Yes.
If you want to take care of that today, we could do what we call a plea in abeyance.
Were you able to see the footage I submitted to the police of our...
Wow. They really did have to get very low budget on the animation. It's no longer animation. It's little stick figures.
Interaction?
I have not watched it, no.
Okay, because in that footage, you can clearly see that the second he tells us to leave, we say, okay, we'll leave. And then he calls the police and said that we threatened to burn down the building and shoot everyone inside. And he was just making up all these lies, which you can clearly see in the footage that we submitted. We were being respectful the whole time. We left the second he told us to.
Sorry, let me look.
And so it makes sense why the police would take me to court, because, I mean, he's threatening that we're going to burn down the building and shoot everyone, but we did nothing. Like, he's just saying that because he's trying to... I'm a documentary maker, so I'm making a documentary on the thing. So
let me explain trespassing just in brief. This doesn't qualify as bona fide legal advice. If you want legal advice, you'd have to come to my law firm, sign some paperwork, and I'll meet with you. Generally speaking, at least in Nevada, I can't speak to other states because I'm not licensed in other states, but in Nevada, through my personal experience, I understand trespassing to be such that if you are in a space where the public is generally allowed to go, let's say my law office, for example, we generally invite random people from the public to walk through our front door during business hours because they might want to consult with an attorney. While it's private property, we are leaving it open for people from the public to enter that private property. Now, if I just don't like someone that happened to enter my law office, I can't just say, oh, I don't like you, you're trespassed, you've committed a crime now, and then the police come arrest that person because, you know, I'm selective as to who I think should have entered my front door and who shouldn't have entered my front door. Trespass generally requires a prior warning. That's why you see no trespass signs you have your whole life. That's your prior warning when you see no trespassing. And if you walked by that no trespassing sign, it could be argued in court that you had notice that you weren't allowed to be there. And with that notice, you entered a certain property knowing you weren't allowed to be there. That would be trespassing. You know, and it gets kind of hairy where maybe there's no trespassing sign, but some trees grew over it and you couldn't see it. Was that notice? Probably not in almost any situation. But if it's clear that you're not supposed to be there, and the property does not belong to you, and it's not public property, then you can't enter that area. And if you're already in that area, when it's made clear to you that you can't be there any longer, you must immediately leave, because if you don't, you've been given notice, and with that notice, you chose to stay on the property. So what Ben is arguing here is as soon as they gave us notice that we weren't allowed to be there in this business that has doors open where people can walk in. We didn't break in when we came in, just walked through the door. And they gave us notice, you can't be in here, and we left. If everything he's saying is true, that's not trespassing at all.
What's going on? It's clear as day in the footage if you watch it. It seems like they're just making up a bunch of false information in order to silence criticism.
So did you submit that to the police officer?
Yes.
Is the footage going such that it's still going, like when you step out the door?
It starts from when we're in the elevator before we talk to him to when we were back in the elevator going back down.
Obviously, a video doesn't necessarily show everything that possibly happened.
So according to the state of Utah, the raw video that shows
The reason why the judge is asking if it shows everything that happened is because then you might have an argument of fact. If the judge were able to see a video of everything that transpired, it would be hard to argue against those facts. Even though the judge might not be able to find ultimate facts on a crime, because that belongs to a jury, a judge is able to determine that the facts are so clear it shouldn't go to a jury, and has the discretion to dismiss a case when they think the facts weigh so heavily it would be a waste of taxpayer money to bring the case to a jury.
everything that possibly could have happened is not credible and could not have shown everything that possibly could have happened. And they didn't even watch it.
What the judge is really saying, and Ben may or may not have known this at the time, is that there remains questions of fact that would have to be resolved because the video did not answer every question of fact that may be in there. And I'll tell you what, I'm going to say this again. If you had another person arguing that instead of Ben advocating for himself, not able to wear the victim hat because he was doing so, that judge may have been compelled to watch the entire video, like I said earlier, by saying, I would like to make a record that I've asked for you to watch the entirety of the video before you make any rulings in this case, so that I might be able to bring it up on a writ or on appeal. So folks, I'd never seen that video before commenting on it today. These are off-the-cuff, extemporaneous comments. If you think I got anything wrong, please leave a comment below. I do have some concluding remarks, though. This is a case that the more I learn about it, and I'm just learning about it in little snippets here and there, but the more I learn about it, the more I'm intrigued by this case. And I think that this case could possibly be one of the most important cases regarding the First Amendment that's happened probably in the last 50 years at least. This could become a seminal case. A lot of things have changed since the last seminal case that I can think of anyway. Supreme Court decision in 1972 regarding freedom of press. So in your First Amendment, you've got freedom of speech. So he's saying things and he's being prosecuted for things he's saying, allegedly, because they're saying that he made threats or that he interrupted the business or something he did with his words or whatever.
If you don't give it back, I'm going to burn the place down. Or we're going to burn the place down. Or I'll kill you.
And then also, you've got this other aspect that's kind of muddy right now as to whether or not Ben is a journalist.
We would be now providing additional information and fodder for this defendant to create videos from which he could profit by placing them on YouTube.
I mean, in the old times, when the founders drafted the First Amendment, the Bill of Rights, or a United States Constitution, what was freedom of press? Freedom of press meant something totally different back then because we had printing presses back then. And the only way to disseminate news and information among folks was you either saw it and you told somebody about it, or you saw it and told somebody that had a printing press, or the people from the printing press company, they saw it and they put it in print. And then they would print out flyers or pamphlets or newspapers or whatever and disseminate them. And that's how things went viral back then. But the definition of journalists has to evolve with the times. Our law has to change as times go on. Technology has brought us new things that change the meaning of journalism. Whereas journalism might have been people that owned printing presses back then and disseminated newspapers, journalists later became people on the radio. And then after that, they became people on TV. And now we have podcasters out there. We have YouTubers out there. We have people that are just a one-man show. They don't have a big production company behind huge movie cameras or anything. They might even just have an iPhone, internet access, and saw stuff or heard stuff. And they're reporting that stuff that they saw or heard. Journalism? Probably so. Because what the founders thought is that there should be a free flow of journalistic information. That we should have not only a freedom of speech, but a freedom of the press, as they knew it back then, to disseminate speech and ideas and thoughts and news. They believed that to be one of the cornerstones of a free society. That society could not be free if you couldn't have a free press. Because if you don't have a free press and it's controlled by the government, we get brainwashed over time. And we're not really free. We're subjects instead of citizens. The backdrop to all of this, when the founders were drafting the First Amendment, was that under British rule, the government could choose who got licenses to use a printing press and who did not get licenses. In other words, we want these guys to do the news, not those guys to do the news. We want these journalists, but not those journalists. And they even went a step further. The British government said, before you disseminate the newspaper, we have a right to preview it and tell you what you can disseminate and what you can't. When the founders broke off from England, they said, no more of that. We want a free press so that we can keep a free society. Hey, if you want some more just lawyer impressions, it's not legal advice, but lawyer impressions on this subject matter or other subject matters we cover, you got to subscribe. Please subscribe below. It also helps our channel, as you well know. Like, tell a friend about us. Thank you. If you want a quick breakdown on the Bricks and Minifigs situation, click this video.